Welcome to the Department of Labor Ruling webinar that we're hosting here today for the Milner Group. I'm Michael Hall, Director of Marketing and Business Development. We're certainly glad you took a few minutes to join us. We know this is a topic of interest to a lot of people. As we have latecomers logging on, we just wanted to make a couple of announcements about how the process of this webinar is going to work. So everybody's line will be muted during the webinar while Chip Anderson is going through his presentation. If you have questions, as we usually do on the webinar, please use the question tab there, and we will ask him the questions there at the end. If there's any additional questions that we do not have the opportunity to get to because of time, then we will make sure we get a response to you. And we're also going to include in this slideshow today, Chip's going to give you his information so that if you have additional questions after the broadcast, you would be able to ask those questions. Since we've got a number of people on the line, did want to mention, if you're close to our office here in Lawrenceville, May the 13th, we have an open house, and we would love to have you join us. We look forward to hosting you that day. We're going to have a Low Country Boil open house event from 11 to 2, and we'd love for you to contact us for additional information if you are interested in attending. As we get ready to introduce Chip, a couple things we did want to mention. One, we know this is a point of issue and a point of concern for many people in the risk management world, and so we have been looking at this very closely here since the process has been ongoing. We know that lots of people are monitoring it, and our goal is to kind of give you a very high-level overview today on how this is going to impact your practice. We'll continue to monitor this. We want all of our advisors to be able to continue their work with their clients in an uninterrupted way. And so today, we have Chip Anderson, who is the Executive Director of the National Association for Fixed Annuities. He has over 35 years of experience in the industry and has been a strong advocate for annuities, both from a product perspective, an advisor perspective, and from the perspective of the consumer. And he and his organization have been working very hard to kind of go through the finalized ruling. And since it's been issued, they've got some things they want to share with us, some important elements of this. And if you still have questions after the webinar, as we said, there will be an opportunity for you to ask questions in the question box. You can always call us and reach out to Julie Stewart or myself. We'd love to get you pointed in the right direction with any questions that you have post-webinar. So with that, I'm going to turn it over to Chip Anderson. He's going to go through, give you an overview, and then there'll be an opportunity for questions that we will ask him at the end. So Chip, take it away.
Thank you very much. On behalf of NAFA and our organization, we appreciate the opportunity that you're giving us to outline some of the information for you all and hopefully answer a few questions. A few things I want to share before we get into it. There are still a lot of unanswered questions that we have for the Department of Labor and how they're going to basically regulate this. There are over 1,000 pages with all the extra pages involved in the Department of Labor report, and it just came out basically a little less than 2 weeks ago. So with our legal team at NAFA and with the attorneys that we have hired, the law firm that we have hired, we're still going through and analyzing a lot of the key points in it, but the information that we have that I share with you today will give you a pretty good idea on how really unworkable and onerous this rule is. So let's jump right into it. How did we get here? Well, this goes back basically, hold on just a second. There we go. How did we get here? This goes back to 1974, and a lot of people have asked, why is the Department of Labor involved in this? It goes back to the old ERISA guidelines that were enacted in 1974, and ERISA, for those of you that don't remember, stands for Employee Retirement Income Security Act. Basically, this handles qualified money. And as you might remember, for those of you that have been in the business for this long, 401ks and IRAs were really insignificant back at that point in time. Over the years, they've grown to be very significant, where it's a huge part of people's retirement money, whether it's a simple IRA or whether it's their 401k plan at work or other qualified money. And I'll mention this a few times, but this guideline, as far as the DOL rule is concerned, is only for qualified money. That doesn't discount the fact that this isn't very important, and here's a couple of key points that you should remember. Qualified money for the fixed annuity business accounts for about 65% of the business. Rollovers, IRA plans, etc., and about 60% of the business on fixed and fixed indexed annuities comes from registered reps or those people that are security licensed. So, significant part of the business is qualified money, and a lot of that business is written by people who are securities licensed. Back in 2010, the DOL proposed this rule, and basically a year later it was shot down because back then the rule was too onerous and unworkable and just didn't make sense at all. They re-released the rule basically 1 year ago, April the 20th, almost exactly to the day that we're talking about right now, and they had a couple of things that proposed through that. There was a public comment period. The first one ended in July. NAFA had a comment letter. The initial rule was 250 pages, and NAFA's comment letter at the end of the first comment period was 25 pages long that addressed specifically the issues in regards to fixed and fixed indexed annuities. There was a public hearing in DC for 4 days that lasted basically 8 hours a day, where a lot of people in trade groups got a chance to voice their concerns over the rule with the Department of Labor. There was a second comment period that ended in September of last year, and then we say the Department of Labor went dark, where they were analyzing the hundreds of thousands of emails that they got and the thousands of comment letters, that they got from different trade groups and different organizations that had major concerns with the rule. Just recently in January, the Department of Labor sent the rule to the OMB, the Office of Management and Budget, so for them to review, and then the final rule was released April 6th, just slightly less than 2 weeks ago. So that's how we got here. Here's some important dates going forward. The rule was released April the 6th. June the 7th in the rule is what's called the effective date. We don't know exactly what all that entails, but quite frankly, I think I would take that term for exactly what it means as an effective date, 60 days from when the rule was released. April the 1st of 2017, a little less than a year from now, there's what's called the applicability date according to the Department of Labor. And then January 1st of 2018, the final rule and complex exemptions are fully applicable. Now, we don't know exactly what these dates mean, and we haven't gotten that information from the DOL, but I would just only assume that the effective date is just what that means. And any actions that are taken, any products that are sold after that effective date, I would think would be under the guidelines of the DOL rule. And the interesting thing is, this isn't what I think, it's not what the DOL thinks, and it's not what the carriers or the state insurance commissioners think. This is left up to the decision of the clients and their attorneys if they feel like they were sold the wrong product or if something was wrong in the sales process. So just keep those dates in mind. You're going to hear from people that say this doesn't go into effect for 1 year, but I would caution you to think that that effective date is not a key date to remember and to be aware of as you move forward and going to do your business. Key points on the new rule, some things to take into consideration. The DOL authority, as I said, applies to qualified money, and non-qualified money is not part of the rule. As we said, that's a significant portion of our business. Fixed indexed annuities, as a result of the last-minute decision by the DOL to regulate them differently than traditional fixed annuities, is an important part of this new rule. Some people thought that fixed indexed annuities would gain a significant advantage by not being part of this, but fixed indexed annuities will be subject to the onerous guidelines of the BICE, B-I-C-E, which stands for Best Interest Contract Exemption, as opposed to what was called the 8424 exemption. PTE stands for Prohibited Transaction Exemption, which is kind of a strange way of looking at things, but there was a prohibited transaction that you could not sell variable annuities and fixed indexed annuities and fixed annuities under the guidelines, but there was an exemption, PTE 8424, that allowed those products to be sold under the old ERISA guidelines. Now, under this new rule, agents and advisors and insurance carriers are going to be required to enter into the type of written agreement, a written agreement at the time of sale, that will trigger fiduciary liability under the rule. In addition to entering into that contract, the financial institution and the advisor must make recommendations and adhere to what's called impartial conduct standards. What does that mean in our terms as far as what we have to do? While we don't disagree with the thought concept here, it's the guidelines that the DOL is setting forth and the restrictions that are put in place that we have a problem with. What this means is that the agent and the registered rep must provide investment advice that is in the best interest of the retirement investor. And that reflects the care, skill, prudence, and diligence that would be exercised by a prudent person under similar circumstances. Well, we don't have a problem with that. The problem we have is who makes that decision. And as I mentioned before, it's not the DOL. The Department of Labor has told us they have no way to regulate this, and they don't intend to. It's not from the carriers. It's not from the state insurance commissioners, because the DOL is now having the authority per se over this and not the state insurance commissioners. Nor is it by the agent to make that decision or what is best. It is left up to the client and the client's attorney 1 year, 3 years, 5 years, whatever time that might be, after the sale is made to determine if they think it was the right sale for them. Next, receiving only compensation that is not in excess of a reasonable compensation, a term that we say remains vaguely defined under the ERISA. What is reasonable compensation according to the attorney out there who thinks the sale was made and the agent or the registered rep was paid too much for that sale or was influenced because of the commission on that sale? Last, not making statements that would be material misleading at the time they are made. We certainly don't have any problems with the concepts here. Again, I just say it's really hard when you leave this to be determined by the client and the client's attorney. Here's what the financial institution must warrant. Their advisors must adhere to the impartial conduct standards, again, very vague, material conflicts of interest that have been identified and documented, and measures have been adopted to prevent conflicts of interest from violating the impartial conduct standards. Very difficult for the financial institutions to do that because they aren't there at the time of sale. It's left up to maybe what the client says versus what the agent or the registered rep says. And their policies and procedures, again, this is the financial institution, their policies and procedures require the use of reliance upon quotas, appraisals, performance or personal actions, bonuses, important part there, contests, special awards, differential compensation, what does that mean? We don't know, and other actions or incentives, i.e. special compensation that might cause recommendations not in the retirement investor's best interest. That could be trips, that could be some type of perks, that could be any extra incentives that the marketing organization or the financial institution, the insurance carriers or whoever might have to encourage agents to sell a particular product or registered reps. All very important. And again, this is left up to the decision of the attorneys and the clients out there on who decides what's in the client's best interest. Definition of a fiduciary. Under ERISA, a person who renders investment advice for a fee or other compensation to a plan, keep in mind here, plan used to refer to like a 401k plan or a pension plan, but now it's under the new guideline and includes the IRA. So under the new rule, the statutory definition has been expanded to include any person who is compensated for making a recommendation to a plan or now an IRA. So just a rollover from an old 401k plan into an IRA or the sale of a new IRA puts the person in the role that they have to be a fiduciary. Specifically, person shall be deemed to be rendering investment advice with respect to monies or other property of a plan or an IRA if that person makes a recommendation as to the advisability, and listen to this part, of acquiring, holding, disposing of, or exchanging securities or other investment property, or a recommendation as to how securities or other investment property should be invested after the securities or other investment property are rolled over, transferred, or distributed from the plan or the IRA. So now just a simple rollover from an IRA to another IRA, or exchanging the 401k plan for a product, is going to be deemed that the person has to be a fiduciary and go under all the guidelines of what the fiduciary standards are. Fiduciary status is triggered if the person making the recommendation represents or acknowledges that they're acting as a fiduciary within the meaning of ERISA or the code, renders the advice pursuant to a written or verbal agreement, which they'll have to do at the time of sale, and the understanding that the advice is based on a particular investment need of the recipient, the client, or directs the advice to a specific advice recipient or recipients regarding the advisability of a particular investment or management decision with respect to securities or other investment property of the plan or the IRA. So really any recommendation, any suggestion, any talking to a client about moving their money from one qualified plan to another triggers the definition of a fiduciary. And this is the question that we continue to ask: who decides what's right and wrong? The DOL doesn't have the authority, and nor do they have the wherewithal to administer this or regulate this, and they leave that up to the clients and their attorneys. I know I've said that a number of times, but I can't emphasize that enough. And it's not within 1 year or 3 years and 5 years. There's an open-ended time frame there in regards to when the client has the ability to act on things. So what does this do for you? What does it mean for the agent? Certainly, bottom line is much more liability. We understand that E&O insurance, because of this new rule, would increase probably significantly, as you would expect. There's going to be more suitability and compliance involved, more suitability and compliance from the carrier's point of view, from marketing organization's point of view, and certainly from the regulator's point of view. Product changes. We expect that product changes will be much shorter as far as their term. You won't see many 10-year products a couple of years from now. I would expect they'd all be shorter term products to fit into a class that would be deemed better for the client or the consumer and less complex, probably not quite as many other indices that you might see out there. And last but not least, because of the shorter term, you'll probably see reduced commissions or going to some type of a trail commission in regards to how the companies will adjust their products if they aren't able to hold on to the money, for 10 years and maybe only have a 6-year surrender charge. So those are things that are going to make it different. What is NAFA doing, you might ask? What have we been doing to try and solve this problem, or at least try and fight it? A year ago, when this rule first came out, immediately NAFA established a DOL working group. We brought together attorneys, we brought together a former insurance commissioner, and key people in the industry to work with us to try and work with the Department of Labor to make changes. As I said, we sent comment letters to the Department of Labor. We met with the Department of Labor face-to-face in July of last year with them to tell them the concerns that we had and how this was going to affect our industry. We had a second comment letter that went to the DOL, and we've worked with the other trade groups trying to work with them to have some kind of an action that the DOL would listen to in regards to how this is going to affect not just our industry, but certainly the consumers, the millions of consumers out there that will not have access to these products, these fixed and fixed indexed annuity products that have safety and guarantees and no downside risk and offer a guaranteed income for the rest of their life, an income they can never outlive. Then, unfortunately, the Department of Labor thinks that those products are not fixed annuities and fixed indexed annuities, that they should be securities products, and that they think that anyone acting and selling a product a safe, secure product like that should be deemed a fiduciary. We have ongoing meetings with our fellow trade groups. We have different meetings every week with different trade groups to coordinate our efforts in regards to trying to fight this rule from that effort as far as the DOL is concerned. And we've also hired a law firm in Washington, D.C. to work with us and explore all of our options in regards to working through the legislative side. We've met up in D.C. With a number of people on the Hill to try and work with them on the legislative side, but we're also working in regards to any litigation that we might have to come up with to file against the Department of Labor. All those things we're doing in conjunction with other trade groups so that we can do that. Now, I know the question that you really have is, what can you do to help? Certainly, the first and foremost, become a member of NAFA, the National Association of Fixed Annuities, and the email address is right there where you can become a member. We appreciate the support. We need the grassroots support for this, but that also allows you to get access to a lot of great information on consumer materials on fixed and fixed indexed annuities, and also to get updates in regards to where we're at on the fight with the Department of Labor on this issue. It keeps you up to date in regards to our efforts, obviously, and be prepared for whatever we need to do to continue to fight this issue. NAFA has a meeting in June, the first part of June, in D.C., and we put together appointments for you. If you attend this meeting, if you're a member of NAFA and attend, we put together appointments with your representatives on the Hill so that you can voice your opinion in regards to the DOL rule. Last year we had 250 visits on the Hill from agents like yourself and registered reps, going up there and listening to the NAFA meeting that we have, and then on Thursday afternoon, the visits on the Hill to meet with your senator or congressman and tell them exactly how this is going to affect your business and how your clients are going to be affected by not having access as they have before to these products. So we would invite you to attend the NAFA meeting. We'll have some information on that in just a second, and that's extremely important. Here's a sales tip for you. You can go to this meeting and come back and use that as a sales tip to help your clients understand that you've gone to DC to help fight for these safe, secure products to make sure that they're accessible for your clients. I would hazard a guess that not very many other agents or registered reps in your town or in your area have gone to Washington, D.C. to actually talk to their senator or congressman and fight for their clients. If you attend this meeting, that can be part of your presentation that you went to D.C. to fight for your clients. Renew your membership if you've been a member in the past, and join NAFA in 2006 to help us with this effort. Frankly, we need your support. We need your financial support. Joe Grecu is our Director of Membership and Development, and there's Joe at NAFA.com. You can reach out to him to help in regards to joining. And then the information is here in regards to June 8th through the 10th, basically, in Washington, D.C., the Hill Walk that we have. This is extremely important and a way for you to express your opinions and go up and visit D.C. and see your senator and congressman, and we'll do all the work for you. All you have to do basically is register for the meeting and show up. So I know that's a lot of information for you, and it's not necessarily good news. We've been fighting this for a year, and we continue to fight on your behalf to try and make sure that these products are available to the millions of consumers out there that need these safe, secure annuity products for their retirement money. We strongly disagree with many of the points that the Department of Labor has come up with in their rule, and we've taken action by hiring a law firm and doing everything we can from the legislative side and possibly the litigation side to fight this rule on your behalf. But we need your support in the way of membership, and we need your financial support to do this. This is going to cost a lot of money and take a lot of time to try and fight this rule so that the American public can have access to these products. I thank you very much for the opportunity, and if there's a couple of questions that have come in, I'll be happy to try and answer any of those questions that came up.
Thank you very much, Chip. I do have a couple of questions here. One question to start with is there any benefit from an insurance or annuity producer standpoint as you read the regulations for partnering with an investment advisor or a register or an RIA? Is there any benefit?
Possibly.
Or does it help?
Possibly, but if you sell a fixed indexed annuity, you have to act as a fiduciary under those guidelines. Really, the source of the money is going to be a consideration, but anybody who looks at this from the standpoint of an attorney, and forgive me, but it's not just about selling insurance products. You could sell the right product for the client, and anybody can say you sold the wrong product. What if the financial advisor was a registered rep and he sold a mutual fund? Under these guidelines, an attorney could come back 3 years later and say, you know, you never should have sold my 70-year-old client a mutual fund or a variable annuity. You should have sold them a fixed indexed annuity that has no downside risk and guarantees. Flip the coin, and that you've sold them a fixed indexed annuity under the guidelines of a fiduciary, and that attorney comes back with the client and says, you never should have sold them a fixed indexed annuity. You should have sold them a mutual fund or a variable annuity or a stock or a bond, depending on what the market did. The client missed out because you sold them a fixed indexed annuity. The client missed out on a lot of growth potential. You sold them the wrong client. No matter what you do, whether you're an insurance-only agent or a registered rep, you could be looked at 2 or 3 years down the road from an attorney with this open-ended rule, and you sold them the wrong product. Now, you might be right, but you might have to go through a lawsuit or litigation because the client brought a lawsuit against you because somebody thought you sold them the wrong product, whether it's a securities product, mutual fund, variable annuity, stocks, bonds, REITs, whatever, or whether it was an insurance product. That's how bad the interpretation of this rule is.
All right. Another question is the QLAC. Is that, if you sell a QLAC, are you considered to be a fiduciary?
I would say yes, because that's qualified money. This entails any and all qualified money. And keep in mind, QLAC brings another part of the U.S. government into this. QLAC is also reviewed and considered by the Treasury Department and the IRS because of the distribution guidelines under QLAC. It's a great question, and any qualified money, any and all qualified money falls under the guidelines of the DOL rule, and you would have to be a fiduciary in dealing with qualified money. Non-qualified money, as we talked about, which is not QLAC, but non-qualified money, in all likelihood, is going to be looked at in the same way, and here's why. An attorney out there is going to look at this, and if you did something on non-qualified money, they're going to say, well, you know what, that DOL rule was out there, and there's fiduciary guidelines and BICE, best interest contract exemptions. You have to do what's in the best interest of the client. Those are out there for qualified money. I understand that doesn't include non-qualified, but as an attorney, I think you should be doing the same thing for non-qualified money as the DOL suggested you do for qualified money. So I'm going to sue you even though it was non-qualified money. Again, that's the worst case scenario, but QLAC falls under the DOL rule because it's qualified money.
All right. Another question, what do you think is more likely to see, large class action lawsuits targeting products and carriers or individuals?
Yes. I don't mean to be flip on that.
Likely.
Yes. And just, you have to look at this viewpoint from attorneys out there. We know for a fact that trial attorney associations are having meetings the last 2 months on how they're going to handle the influx of business from this DOL rule. This is an open-ended opportunity for attorneys to get with clients, and whether it's insurance carriers or clients or anyone who is in the process of distributing these products, financial services products, whatever there might be. This isn't limited to just fixed indexed annuities. This is just the area that we focus on. Any financial services product that is sold going forward under the new DOL rule is going to leave any salesperson, any carrier, any organization open to litigation and liability from an attorney.
So will you expand on that? There is a question. So under that concept, then you know, a supplemental retirement life insurance policy would fit into this just as easily as an annuity sale.
In regards to if it's qualified money, it does fit automatically into it, but generally any product that is sold out there that is, and again, I'm not an attorney. We have attorneys on staff at NAFA, and we work very closely with the law firm that we've hired and also attorneys with many of the carriers. But I think anybody who sells a financial services product, and this is my interpretation, leave themselves open to any criticism if it's in the retirement, if it's in the best interest of the client for their retirement, no matter what the product is, whether it's qualified, non-qualified, whether it's a life insurance product or whatever that might be. The health underwriters are looking at this. Even plans that are out there for health insurance leave themselves open to interpretation for the DOL rule. Long-term care, that might leave yourself open to this if there's what's called the fiduciary standard and the best interest guidelines that the Department of Labor has set up. As an attorney, you might be able to pull that in and say, they didn't act in the best interest of the client selling them this life insurance, nor did they act in the best interest of the client selling them this long-term care plan. The best interest guidelines are out there. Everyone should follow those.
Okay. One last question, Chip, as we wind this down. Just from a cost perspective, what do you think this is going to cost the industry in terms of compliance and regulation, and is there any way at this point to derail it or to kind of get back to the way things were?
Yes, there is. I'll answer the last part first. Yes, there is a chance to derail it. We're working hard on that, and as I said, we've hired a law firm in D.C. that specializes in this area. The Department of Labor has made some mistakes. They have overstepped their boundaries in regards to looking at this. They did not do a cost-benefit analysis to see what this was going to cost the insurance industry and the financial services industry and the American public. There's a lot of things they did wrong. This is done by the current administration wanting to push this through because they don't like the big insurance companies, they don't like the big financial institutions, and you've heard a lot of that in the political things that have come out there. That's the way that we're going to fight that, and in all likelihood, the only resource we have besides the legislation aspect is litigation. So that's a consideration for us in regards to how we're going to handle that. What cost effect it's going to have on insurance carriers, marketing organizations, and the individual agents, it's going to be dramatic, but we won't know for a couple of years. There's going to be a huge, huge increase in regards to compliance and suitability standards. Websites are going to have to be set up to explain all aspects of the sales process. That's a requirement. Full disclosure on all commissions will have to be made, so there'll be forms on that. Everyone will have to know exactly how much commission is involved in the sale of a product.
All right, well, we've reached 2:30, so we are going to go ahead and cut it off here. There are a couple of questions we didn't have time to get to, but we will forward them to Chip and make sure that he gets a chance to respond. And we certainly thank you for joining us for the webinar. We thank Chip very much for his time, effort, and energy as they try to help us and the remainder of the industry as well as the consumer. So thank you very much for joining us today. We hope you have a great day. Thanks so much.